appeal in the matter of McDonald and Excalibur Keswick Groundworks Ltd and Appellant.
Yes. Yes, it is.
May it please the court. I appear on behalf of the appellant, Mr. Hogan appears on behalf of the respondent.
Yes. Good morning. Well, thank you very much for taking the second row. Just would you hold in mind then that you're just a yard or two further away, so that
Certainly.
We can hear you both.
Thank you, my lord. As you know, this is a second appeal brought with the permission of Lord Justice Lewison on the 24th of May 2022. And the appeal raises important points of principle or practice, I say, relating to personal injuries litigation. I'll identify these before developing my submissions on the law and then seeking to apply those to the facts of the case, if I may.
Thank you. Well, before you set off, could you just help us as to how you see the timing of this appeal as going? I have to say, particularly given the amount of help that you've both given us in writing, we don't think we're likely to take the day or anything like the full day.
No.
But please tell us how much time you think you're going to need. And then I'll ask the same question.
My Hogan and I did actually discuss this before we came into court, and we both take the view that a day might be a little long. The submissions are more than skeletal in the written argument, and I certainly don't want to read out my written argument. I'll take it as read. I'll supplement it, but I certainly shouldn't be more than an hour at the outside, possibly less. Well,
I don't ask in order to put you under any time pressure at all, but just in order that we have our general feel for the day. And coming to you then, Mr. Hogan, how are you situated?
I would have thought I'll be an hour again.
Yes. Well, again, we're not going to be clock watching, but I think we'll either finish it within the morning or not far short of that. That's helpful. The second thing that we'd like is, again, not by way of complaint. There are a lot of grounds of appeal. I imagine that when you come to develop them, you're going to help us by starting by boiling them down to grouping them to a number of propositions. But it certainly will help us if, in a sense, we know that you have essentially this limited number of submissions and that Mr. Hogan is meeting them head on, so that you don't pass each other unanswered on any point. But we're not going to be ruling on 11 grounds of appeal. That won't surprise you.
No.
All right.
Thank you for the indication, my lord. So I said that there are a number of issues. That the first issue concerns the power of the court to strike out a claim under CPR 44.15.1c. The district judge interpreted that provision purposively in light of the overriding objective, and took the view that the respondent's conduct merited a strikeout. On appeal, Judge Freedman held that a strikeout was available under that provision only if the relevant conduct rendered a fair trial impossible. And the appellant contends that that is the wrong test, and that conduct that impedes or hinders the just disposal, i.e. the process of resolution of the proceedings, qualifies. It's not necessary that the conduct renders a fair trial impossible.
We'll be grappling with that submission, but can we just consider the question of the sequencing of the issues in this case? In the actuality, this all started with the filing of a notice of discontinuance. That then is met by an application to set that aside, followed by an application to strike out. Now, is there any particular reason why we should not approach the legal arguments in that sequence?
No, although perhaps they could be rolled up together as a sort of purposive construction of three rules.
But certainly, because you'll appreciate that speaking for myself, this is not my core experience, and so anything that can match what happens in real time with the legal questions that have to be answered as one goes along might be easier, at least for me, to follow. So would you like to just identify what your essential questions are and then explain to us how you would see it as the ordering of them as being best for all purposes? So you've started with, in any case for the moment, with the strikeout
Yes.
power.
And we could approach them in the opposite direction. In fact, we could start with notice of discontinuance.
So what is your list before we decide what order to take it in?
So the second issue concerns the circumstances in which it's legitimate to set aside a notice of discontinuance under 38.4. The district judge obviously proceeded on the basis that she had a generous discretion there. Needed only to be exercised in accordance with the overriding objective, whereas Judge Freedman took the view that 38.4 was available only if there was conduct that was, for example, so cynical or egregious as to justify invoking 38.4.
Yes.
So that is the second issue. And as I say in my skeleton, the third issue is really a combination of the two.
And that's the quox.
It is, if a person injury claimant
Yes.
conducts himself in a manner whereby his claim is eligible to be struck out and his quox protection is eligible to be disapplied, what should the court do if he discontinues his claim with quox protection intact? And the defendant asks the court to intervene in two, we would say, difficult cases, Mabin English and Shaw and Medtronic. High Court judges have stated that the court should do nothing unless the discontinuance was cynical or egregious or amounted to an abusive process. And the judge in the Shaw case, Mr. Justice Lavender, was sufficiently concerned about the potential to work injustice that he invited the Rules Committee to consider whether the rules needed to be amended.
Yeah.
4 years later they haven't been, and the appellant says respectfully that is because the rules applied in a non-mechanistic way, applied purposively, can achieve justice without amendment.
Right. Well, again, before we get too far down the argument, it seems to me that you've given us a three issue program, and one might, I suppose, start with the second issue, which is the setting aside, before then moving to the strikeout, and then it all ultimately coalesces around the third point. Would that, it's your appeal and you must argue it as you think best, but would that be an alternative and maybe more logical way of going into this?
Yes, I'm perfectly content to approach the case that way.
Thank you.
So, looking at the rules, CPR.
Mr. Higgins, approaching it in that way, so we're doing notice of discontinuance, then the power of the court to strike out, and then we have what might be termed the quox issue.
Yes.
Right. That being so, can I just take up my Lord's point? You have relied upon 11 grounds of appeal. Speaking entirely for myself, I really want to know what are the bull points today, because we don't need 11 grounds of appeal.
No.
And as my Lord has already indicated, it is important that both you and Mr. Hogan are identifying the same points so that Mr. Hogan can answer them. So what are they, please?
So looking at the grounds.
You don't need 11. It's not going to help anyone.
Yeah. Let's see.
No, that was probably a kitchen sink approach that ought to have been revised when the rest of the kitchen was put in. So, ground one, erred in law.
So at page 13, are we?
Page 13, my lord, yes.
Yes.
Ground one, erred in law by misinterpreting the meaning of the words likely to obstruct the just disposal of the proceedings. That's clearly in play. I say that the just disposal of the proceedings is resolving the proceedings in accordance with the overriding objective. Actually, the mirror image of the overriding objective, obstructing the just disposal of the proceedings. So that clearly is in play. Erred in law in his application of CPR 4415.1, it's probably the same point, so
It
we
is.
take that out. erred in law in holding it was not possible for the district judge legitimately to have concluded the claimant's conduct was likely to obstruct the just disposal of the proceedings. Well, I suppose that's an application of one to the facts, so that can stay in. Erred in law by misdirecting himself as to the test to be applied when considering whether to set aside notice of discontinuance. That's in play. Erred in law is application of that can come out. Wrongly held that he was bound by decisions in Mab and Shaw. I'm not going to press that particularly vigorously because obviously this court can override Mab and Shaw if it wants to. So put that in parentheses, but probably not developed to any significant degree. Erred in law by considering whether the claimant could be struck out first and only then considering whether the notice of discontinuance ought to be set aside. I'm not going to press that. I don't think that how one approaches this sequence of decisions actually affects the outcome, because if the application falls at any of them, then it doesn't get from A to D. Erred in law in adopting a two-stage process.
What's that in respect of?
So that is my submission, that one needs to aggregate the effect of 38.4 and 44.15.1c and use those two rules simultaneously and purposively so as to achieve the overriding objective, rather than applying them individually and sequentially, which is my Quox point, my third point, as it were. I accept to some extent, because one can't possibly process two different tests at the same time simultaneously. What I mean there is that one should analyse both criteria, but before making a decision on either, aggregate one's decision-making and thoughts across the two concepts before then aggregating them into a final decision, rather than picking one off first, dealing with that on its own, and then saying, well, that's the end of it. 9, wrongly treated the claimant as someone who is at risk of being dislodged from a judgment seat against their will. That there is some tension in the case law. Case law ordinarily involves people who are discontinuing and submitting to an enforceable cost order. And the jurisprudence surrounding those sorts of litigants might be different to persons who are seeking to discontinue and not have an enforceable cost order. Equally, when looking at the application of 3.4, one is generally looking at litigants who want to remain in play, that they fight against being struck out, rather than this claimant who has decided that he no longer wished to proceed. And so to that extent, categorising or treating the claimant as someone who is at risk of being dislodged from the judgment seat against their will, which is what a lot of the cases are concerned with, was, I submit, an error of law. A very simple point, doesn't need much development, but I'm not going to withdraw it.
Can you just tell me in simple words what you're actually saying on ground of appeal 9?
Yeah, so what I'm saying is that where the judge has regard to case law, which analyses the utilisation of 3.4, almost all of those cases, in fact, all of those cases concern litigants who don't want to have their claim brought to an end. And that is not this situation. And by not distinguishing between Mr. McDonald, who had decided that he did not wish his claim to be pursued any further, and treating him in the same way as, for example, Mr. Blackledge in the error nominees case, who wanted to carry on, he fell into error. Like comparing apples and pears.
Right.
10, failed to bring into account any analysis as to whether the claimant was deserving of court protection. That is something that I wish to develop. then wrongly set aside the decision of the district judge, well, it's a wrap up, and I don't need to press that.
Right. Well, I think to some extent the grounds of appeal as drafted aren't necessarily following this discussion where one would wish to be taking off from. And so what I am going to ask you to do, if you would, assuming that you'll start with discontinuance, then go to strikeout, then go to quox in that order, is to introduce each of your submissions on those three matters with a concise statement of what your position is, and to enable us to understand how you say the judge went wrong. So if you could do that at the beginning of each, we'll then see how that sits with any grounds of appeal that we've been considering. All right, so can we then start with notice of discontinuance?
Yes. So the 38.4 is set out in the authorities bundle at page 5. And 38.41 states, where the claimant discontinues under Rule 38.21, the defendant may apply to have the notice of discontinuance set aside. The judge proceeded on the basis that he should not set aside unless there was conduct which was so cynical or egregious as to justify setting aside the notice of discontinuance. The appellant submits that that was wrong, that there is no, the rule does not say that conduct needs to be so cynical or egregious before a notice of discontinuance set aside, and that the rule needs to be interpreted in the context of the overriding objective, provided that the discretion conferred under 38.41 is exercised in a manner which furthers the overriding objective, then that exercise of discretion cannot properly be impugned. And to add an additional layer, that 38.41 is not engaged unless a litigant has conducted themselves in a way that's so cynical or egregious, is to fall into error. The appellant says that 38.41 provides a broad discretion which can be exercised purposefully in accordance with the overriding objective, which of course includes, so far as is practicable, saving expense, ensuring that the case is dealt with expeditiously and fairly, and allotting it to an appropriate share of the court's resources, while taking into account the need to allot resources to other cases.
Right, so this is the counterpart of 38.2, which is the right to discontinue.
Yes.
So 38.2, a claimant may discontinue all or part of a claim at any time.
Yes.
And then there's the right to apply. Now it's set aside. I'm looking at the White Book at 1330 page.
And a subsidiary point I make here is that much of the case law on 38.4, in fact, almost all of the case law that the court has already looked at and will look at during the appeal, concerns litigants who are seeking to discontinue and pay costs, not litigants who are seeking to discontinue and not pay costs. There is a distinction. And in my submission, one has to view 38.41 in a quox case through the prism of the overriding objective, and in particular, the court's need and the party's duty to ensure that a case is allotted an appropriate share of the court's resources and doesn't consume resources that other litigants ought properly to have.
Well, surely by discontinuing, you're doing precisely that. You're taking it out of the list, and so there's more time and no further money has to be expended.
But the point is that the discontinuing at such a late stage, where all of the costs of the litigation have been incurred, there was no cost saving at all occasioned by discontinuing after the trial had started, and where almost all of the judicial resources required to deal with that case have been consumed. Yes, there was a saving of perhaps a couple of hours, because the cost argument didn't even begin until 2:30 on the day of trial. It was listed for a one-day fast-track trial. So any saving of court time was de minimis. And when viewed, looking at the overriding objective, this was a flagrant breach in my submission of the claimant's duty to assist the court to ensure that an appropriate share of the court's resources was applied to this case. If the claimant was going to have a late re-evaluation of the merits of his case, as a learned friend puts it, something which I don't agree that is what's going on. If the claimant is going to do that, the evaluation should come at a much earlier stage in the proceedings and not 500 odd days after a witness statement has been served, which runs counter to the pleaded case. So in my submission, one has to look at 38.4 through the prism of the overriding objective, looking at what has happened in the case and looking at the fact that in this case, this claimant had consumed almost all, if not quite all, of the resources that a fast-track litigant is entitled to have allocated to them.
But your principled argument is that the court ought to approach 38.4 differently in a PI case to which the Quox regime applies.
Yes.
Right. Well, it's not what it says, but the argument runs that the terms of the overriding objective justify that submission.
Yes.
Now, you mentioned, and obviously, and for myself, focused on this, but you say that the witness statement that was inconsistent, you say was 500 days before the trial.
Yes.
So why didn't you apply for summary judgment when you got it?
Because presumably, I don't know. I personally didn't have conduct of the case until.
No, but what I mean is that it's not that I appreciate how this looks from the point of view of the defendant, but it's not as if the defendant is without remedy. I mean, if you say that the claimant only woke up to the hopelessness of his case once the trial had been called on, the same seems to be true of the defendant.
The defendant asked for the claimant's case to be clarified before the claim was fully opened.
That was on
you mean on the day?
On the day.
On the day of the hearing.
Yes. But I mean, if there is and this is not said in any critical sense, you understand, but we're thinking of the principle of how the rules work and can work fairly for everybody. It seems as if this is a case in which people only really put their mind to the significance of the discrepancy that led to the discontinuance once the trial was upon them.
Yes.
And that applies to both parties. And so I'm pressing you on this because if you say that it should all be done differently because of Quox, I don't understand why that should be the case when you could have applied a normal civil remedy and simply gone and had the case dismissed on a summary basis.
If that had happened, there probably would have been an application to regularise some aspect of the case, one supposes. There's no duty on a defendant to make an application for a claimant to regularise their case. They're perfectly entitled to sit back.
No, I wasn't suggesting you should apply to have them improve their case. I'm suggesting that you should apply to have it dismissed on a summary basis, or if it was bad enough, to have it struck out.
Well, firstly, that there is no duty on a defendant on any party to cause their opponent's case to be regularised. That's the first point.
Yes.
The second point is that we're now heading off into the facts of this case rather than looking at the generalities. On the facts of this case, the primary burden was upon the claimant to regularise his own case himself, not upon the defendant to make an application for the claimant to regularise his case. and if the defendant made its application on the day of trial, it will be dealt with on the day of trial.
I think my Lord's point is that you lay great stress on the overriding objective, and it applies to everybody, doesn't it?
It does.
And you did nothing.
Well, we did nothing, but the primary burden is on the claimant.
Yeah.
We are in a secondary position. So whilst I'm prepared to shoulder some criticism, the majority of the criticism must, with respect, be directed at the defendant.
But I wasn't, you understand, I've said it once, I wasn't intending this as a criticism. It's just trying to understand how the rules operate. And there you are, a defendant to a PI claim who knows that costs are running against them on the face of it. And so we have to consider whether, in principle, that means that you can wait till the end and then get the discontinuance provisions operated in a different way because of quox, which is what you're saying is the correct position.
I'm not sure I'm saying that. I mean, I'm saying that even if the application had been made earlier, then the same principles would have applied. The claim would have been struck out, and quox would have been disapplied. The fact that it occurred later on is nothing to the point.
All right, thank you.
So 38.4, in my submission, gives a wide discretion, which has to be exercised in accordance with the overriding objective, and it would be myopic to construe the overriding objective in a quox case without bringing into account the fact that quox is going to have an effect on the allocation or certainly the enforcement of costs. Something that the court should have a keen eye on in my submission when deciding whether or not a notice of discontinuance should be set aside. Going to move then to 44.15.1c. And the relevant provision is in the bundle.
It's at tab 4,
Thank you
page
very
6.
much. Thank you very much, my lady. 44.15.1c. Orders for costs made against the claimant may be enforced to the full extent of such orders without the permission of the court where the proceedings have been struck out on the grounds that the conduct of the claimant or a person acting on the claimant's behalf and with the claimant's knowledge of such conduct is likely to obstruct the just disposal of the proceedings. So looking at those words, likely to obstruct the just disposal of the proceedings, what do those words mean? Well, the disposal of the proceedings, as I said in my skeleton, is in my submission, the resolution of the proceedings one way or the other. Proceedings obviously is the claim, and the just disposal of the proceedings brings into account justness when deciding this particular provision. And the overriding objective, which we've already touched upon, as originally enacted, these rules are a new procedural code with the overriding objective of enabling the court to deal with cases justly. Dealing with a case justly includes, so far as is practicable, ensuring the parties on equal footing, saving expense, dealing with the case in ways which are proportionate, etc., ensuring it's dealt with expeditiously and fairly, and allotting to it an appropriate share of the court's resources whilst taking into account the need to allot resources to other cases. So the just disposal of the proceedings is the resolution of the proceedings in a manner consistent with the overriding objective. And in my submission, running a threadbare case to the doors of the court and then discontinuing on the morning of trial is the antithesis of the overriding objective. It consumes court resources that have not been consumed gets in the way of other litigants who wish to have their claims dealt expeditiously and fairly. It doesn't do anything to reduce costs. In fact, quite the opposite. All the relevant costs have been consumed. And in my submission, dealing with a case, conduct likely to obstruct the just disposal of the proceedings includes precisely the sort of conduct that occurred on this occasion.
So when you say the conduct which occurred on this occasion, you are saying a pleaded case in the statement of case, and then what you would say is an inconsistent statement made by the claimant in his witness statement. Is that it?
So it's slightly more than that. There's a pleaded case. There is a statement which is the opposite of the pleaded case, such that the statement, if accepted at face value, would not actually make out the pleaded facts, coupled with no application to regularise either the statement or the pleaded case so that the two are synchronised, and then appearing at court, apparently with counsel not knowing what your case is, the case having to be stood down to discern what it was, even then there being some confusion, the court giving further time, at which point the case was discontinued. Behaving in that way, running a case for 500 days, and then on the day of trial discontinuing in that manner is, I submit, conduct that is likely to obstruct the just disposal of the proceedings. It has obstructed the just disposal of the proceedings. The proceedings have not been resolved justly in accordance with the overriding objective. They have consumed court resources. It has been a waste of time. And in my submission, that comes within 44.15.1c.
Can we again seek to set sub-paragraph C within the context in the rules? I'm looking at it in the White Book. We have 44.13 and 14, which deal with general definition and effects of quacks.
Yes.
And a certain number of notes appear there. We then have 15 and 16. 16 benefits from quite a lot of discussion, right? Amongst other things, fundamental dishonesty.
Yes.
But when one looks at 15, which is what you're concerned with, we see that orders for costs may be enforced to the full extent without the permission of the court where proceedings have been struck out. So this is an exception following a strikeout.
Yes. Very curiously, the terminology in 44.15 isn't synchronised with 3.4.
No, conduct rather than statement of case.
3.4.
Yes.
That refers to statements of case.
Yes.
In fact, there is no standalone provision in the rules that creates an ability to strike out proceedings. There has been a case, Appellant's decision of Mrs. Justice Rose, in which she struck out a statement of case but didn't strike out the proceedings and said proceedings are still extant.
Right.
You, Mr. Claimant, can now replead your case from scratch. It's rather interesting, actually. The rules don't contain an express provision enabling the court to strike out proceedings. Of course, there must be one because...
Well, we're happily not here to consider that, but looking back at sub-rule 15, one sees that the proceedings are struck out either on no reasonable ground or an abuse. We're not concerned here with either of those provisions, are we?
No.
No. We're under C, as you've been dealing with, which is obstructing just disposal. Can you then just help me at least for how that fits together with 44.16, which is to do with the enforcement of costs where there's been a finding of fundamental dishonesty? How do those two sub-rules sit alongside each other for purpose of context?
They are alternatives, clearly, to each other. So alternative gateways to achieving an enforceable.
Right, so in one case it's where a claim is struck out, and in another it's which at the end of proceedings there's found to be fundamental dishonesty. Those are the typical situations.
There can also be cases in which the claim is discontinued, and
Yes, but,
the court goes on to make a finding of fundamental dishonesty.
But the 16 doesn't require a strikeout, is that it?
No.
Right. 16 is for other circumstances in which similar concerns might be felt about
Yes.
retaining Kwok's protection
And there has to be a finding by the court.
of fundamental dishonesty.
Yeah.
Right. Now, my reason for stepping back a little bit is to ask you whether anything in 15 gains any, in what it means, as it were, obstructing the just disposal of proceedings, gains any colour from what happens under 16, where you don't require a strikeout.
In my submission, the two are alternatives, and they don't inform each other.
Right, so you can, so if you don't get struck out, you've got to be found to be fundamentally dishonest to lose your Kwok's
Yes.
protection.
Yes, that must be right under the rules.
But if you do get struck out, you say that something less than fundamental dishonesty may deprive you of cost protection.
Or something different to fundamental dishonesty.
Well, I think you'd take an aim at the cynical and egregious label that the judge applied. So it rather looks as if it might be easier for you to disapply Kwok's under 15 than 16, if you're right.
Well, yes. I mean, fundamental dishonesty as a concept has been chosen as the barometer for the operation of 4416. However, conduct which is likely to obstruct the just disposal of the proceedings is just that in my submission. If a claimant conducts themselves in a manner which is likely to obstruct the just disposal of the proceedings, and of course Judge Freedman interpreted that as meaning that a fair trial was impossible.
Well, he took that, didn't he, from the words of Chadwick?
Yes. I say that Judge, with the greatest respect to Judge Freedman, he was wrong. One doesn't need to operate on the basis that if a fair trial is possible, a claimant has not obstructed the just disposal of the proceedings, because that is to relegate or neutralise all of the other parameters within 1.1 to points of no weight. And dealing with a case justly, the just disposal of the proceedings is one that occurs in synchronisation with the operation of 1.1. It is simply impermissible to sever any analysis of 1.1 from the interpretation of every other rule in the CPR. And Judge Freedman, with the greatest respect, appears to have done that, operating on the basis that unless a fair trial was impossible, then 4415(1)(c) was not engaged and never could be engaged. And this is the wider point in my submission, that one can, ignoring the facts of this case at the moment, probably not particularly why we're here, it's the wider point here, which is that if a claimant's claim is eligible to be struck out under 4415(1)(c), but he discontinues, even if the defendant had made an application to have his claim struck out, which was pending, is it the law that the court will not set aside that notice of discontinuance unless a fair trial was impossible? In my submission, that must be wrong. It can't be a race as to who gets into court first, particularly where one of the parties has the ability to achieve a particular objective without going to court by serving a notice of discontinuance. That operates immediately, whereas a defendant who is seeking to have a claim struck out needs a judge to do that. Of course, if we had infinite resources and judges available 24/7, one could make an application to strike out and have a judge come online immediately to hear it. But we don't operate on that basis. We have delays of months between applications being made and strikeout applications being heard. And during that interval, a claimant can discontinue. The question is, what should the court do about that? Can the court do nothing about it, as Judge Freedman appeared to say, unless A, it's cynical and egregious, and B, a fair trial is impossible? Unless those two tests are met, the court can do nothing. I say that the analysis of that with the law is much more open-texted than that. The court needs to bring into account 1.1 and needs to look at this purposively, having one eye on the purpose of quox protection, who it's designed to protect, and not using the rules mechanistically, sequentially, individually, 38.4 followed by 44.15. One has to aggregate the operation of those two rules, viewed through the prism of 1.1 to achieve a just result. And forgetting about the facts of this case, one can readily imagine cases where the just result would be to say to the claimant, you will have an enforceable cost order against you. Your notice of discontinuance will be set aside. And in my submission, even if a fair trial is possible, that will occur in some cases. And that is the nub of the appeal in my submission, whether the judge's approach was wrong as a matter of law. And in my submission it was.
So a judge faced with a position of this kind, on the assumption that it can't be said the claimant's disclosed no reasonable grounds for bringing the proceedings at all, and it's not an abuse, then 44.115c involves the judge assessing the conduct of the plaintiff by reference to the overriding objective.
Yes.
As a general discretion.
General discretion, but one that judges will be readily familiar with. One knows whether a claimant has conducted themselves consistently with the overriding objective or has obstructed the just disposal of the proceedings. I did include in the authorities bundle case of Atos Consulting, where the parties agreed that parties agreed, and the High Court judge in that case didn't disagree, that obstruct can mean impedes to a high degree. So certainly that case runs counter to Judge Freedman's analysis, which is that obstruct means render impossible. That obstructing the just disposal of the proceedings is only satisfied if a fair trial is no longer possible.
Right.
Well, I can see that there's a difference between impossible, between obstruct in one sense and obstruct in another sense, and it's maybe important that we choose the right sense of that. But what difference would that make to your case here? I mean, are you suggesting that that the claimant's conduct impeded the just disposal of the proceedings to a high degree?
Yes.
Or just by continuing?
By running a threadbare case for more than a year, in circumstances where the witness statement was not synchronised with the evidence, in circumstances where the medical records, which you will have seen from my skeleton argument, I haven't trouble with those, identified a different cause for this man's falling over.
Well, one part of the medical records did.
Yes.
Yeah.
Well, various parts, in fact. There were 4 different entries, all containing discrepant accounts versus
Yes.
So clearly concern there as to what precisely had occurred. So a case that isn't synchronised with the evidence, a case that doesn't fit with the contemporaneous medical records, run all the way to court, the judge picking that up on the morning of trial when the case had been opened, so the case had started, saying to the claimant, what are you doing with this? Your case, your evidence in your case is not synchronised. And the claimant then deciding to discontinue.
But all the time the defendant is sitting there knowing exactly what the material is and, let us be clear about this, knowing it's fodder for cross-examination and doing nothing.
I refer to my earlier submission that the primary burden is on the claimant.
Yes, there is. You can put it in those terms, but you're not suggesting that there wasn't a burden on the defendant?
I am, actually. There is no duty.
No duty.
Of the defendant to make an application to regularise the claimant's case.
So you sit there waiting for the trial, knowing you have fodder for cross-examination.
Well, there's always the possibility that the claimant would have made an application to amend either the witness statement or the particulars of claim.
Yes, which is why it's probably a good idea to have got in early.
Yeah.
But I think my lady's point is that we're not concerned to impose a duty on defendants, but simply that your answer, which is it's not up to us, only takes you so far. I mean, we're attempting to interpret the rules in order to create a procedural code as fair as possible.
Yes.
And so it presumably must be open to us to look to what other remedies you have in a situation of the kind of which you complain.
Well, the remedy that would be available, say an application to strike out or application for summary judgment.
Yes.
There would be a very real risk, tactically, that such an application would be met by a cross-application to regularise one or other of the witness statements or the pleadings. So is it seriously suggested there's a burden on a defendant there to jog the claimant into regularising his case, and then
But I mean,
in a worse position
you put your finger on it. Effectively, you're saying that defendants should be able to let sleeping dogs lie for as long as they want, and in a sense, then pounce.
Well, there is an element of that.
Yes.
Yes. I'm not saying that the defendant doesn't have a duty to further the overriding objective. I don't have the case law with me, but I certainly remember there being quite a substantial body of case law that says that there is no duty on a litigant to assist the other side to get their case in order, that is settled law. And whilst I accept that there will be some shading into the overriding objective, the substantive law is that there is no duty. And if your opponent has made a mess of their case and is trundling along to a point where the case is going to be struck out, you don't have to put them on notice that actually they are heading for a fall.
But here, just to get the chronology right, the notice of discontinuance proffered on the day and opposed.
Not opposed, the application to set it aside was made.
The application to set aside was made. What was done about strikeout?
That followed on from there was a rolled up application.
Yes, and before the district judge. So all of this was done, as it were, on the hoof.
Yes. In
the light of what had happened at the trial. And so in order to... So in those ways, the application to set aside the notice and the application for strikeout substantially engage the same principles. Is that right?
There were not two applications separately decided. There was one application, a rolled up application under 38.4, and I mean, not actually under 44.15.1c, because as your Lordship rightly pointed out, that determines the effects of a strikeout, but there was an application to strike out for reasons that would then be covered by 44.15.1c. Yes,
but we know what the criteria for a strikeout, so far as is relevant for this issue, because it's in 44.15.1c.
Yes. So I used the phraseology from 44.15.1c as the basis for the application to strike out, even
Yes.
though there does not appear to be an express provision enabling
So
such a
that's
strikeout to occur.
one thing that you could get a strikeout based upon.
Yes. So by arguing that 44.1c is engaged, it's difficult, I suppose, for a judge to say, well, I can't do that because there's no power. So yes, they were rolled up as sort of double application dealt with simultaneously, rather than sequential applications dealt with individually. And the purpose of dealing with them together was because I say one has to apply the rules purposively to achieve justice, and that can be done when one is using the two rules symbiotically to achieve the overriding objective.
Right, so what is the fallacy then, and how did the judge approach it as a two-stage process that defeats that? Could you just walk us through that?
So by severing the analysis of the two rules from simultaneous engagement,
Yes.
one puts oneself in a straitjacket where one is not looking at the overarching.
Right, so what did the judge do first? Just remind me.
So the district judge.
Let's deal with the judge
Sorry,
first, because it's his decision that you challenge.
the circuit judge. Judge Freedman.
Yes.
So if I may just pull up my. So what the judge did, firstly, at page 84 of the bundle, paragraph 55, he asked himself what he said was the first and fundamental question.
Yes.
And that question was whether the claimant was guilty of such conduct as to be likely to obstruct the just disposal of the proceedings. And he elucidated in paragraph 56 what he understood obstruct the just disposal.
Right, going back to 55, do you have any concern about that statement, that the first and fundamental question, etc.?
Yes.
And I thought you'd just been addressing this on the basis that one could really roll up the notice of discontinuance and the strikeout, and the strikeout would have to be on that very basis, conduct likely to obstruct. So at the moment I'm not understanding why what the judge sets as his point of departure is objectionable.
Sorry, the point of departure is not objectionable.
Right.
It is the process of departing that is objectionable.
Right. Okay. So you're happy with his first and fundamental question,
Yes.
or at least first, let's call it. Right. And so where does he go wrong?
So in paragraph 56, he says the question is whether the appellant's conduct rendered a fair trial impossible.
And that's what he's taking from the decision of Chadwick in our nominees.
Yes. Which is a case in which the party applying their submission was that a fair trial was impossible. So that is why that test became utilised in that case. It's wrong in my submission to say that unless a fair trial is impossible, then that is not conduct likely to obstruct the just disposal of the proceedings. That is the error the judge fell into in my submission.
I'm sorry, the fault is wholly mine. Just run that past me again.
So in the Arrow case,
Yes.
the applicant who was seeking to have the claim struck out said that 3.4 was engaged because a fair trial was impossible. And so the court focused on whether a fair trial was impossible and concluded that it was. One cannot extrapolate from that to say that unless a fair trial is impossible, 3.4 C can never be engaged.
Right, so you say Arrow is case specific.
Yes.
Right. At some point, I'm going to need to look at Arrow. Is this a good point for you to show us this, or do you want to continue with the analysis of the errors?
Shall I continue with the
yes, while we're on this page.
Come back to Arrow later
Please.
on. The judge posed an alternative question, really the same thing put a different way. The question needs to be asked as to whether his conduct corrupted the trial process so that a just result could not be achieved.
Yes.
And then having answered those questions in the negative, and held that the district judge would have been wrong to strike the case out because the facts before the district judge did not admit of the possibility of the claim being struck out, he then moved to the procedurally anterior question, whether the notice of discontinuance ought to be set aside. So my submission on the first and fundamental question, whether the claimant was guilty of such conduct as to be likely to obstruct the just disposal of the proceedings, the judge fell into error there in equating that test, or stating that that test would only be satisfied if the appellant's conduct rendered a fair trial impossible. That's not what the rule says. And the rule doesn't say that the rule will be engaged only if the conduct corrupts the trial process so that a just result could not be achieved.
You've offered as an alternative to the judge's formulation the application of the overriding objective to the facts of the case. But what is that is so broad as not to amount to a test at all, surely, because no claimant could possibly know what their fate would be on cost protection if they press the discontinue button, simply to be told that the court will have a broad discretion applying the overriding objective. That's not a workable test in a sensible world. So are you prepared to hazard or even give examples of the sorts of cases that that come within sub C? What is your alternative test?
So my alternative test is based upon the wording in the rule, that conduct that obstructs the just disposal of the proceedings.
Any conduct?
Well, relevant conduct. Relevant conduct that obstructs the just disposal of the proceedings engages the rule.
But I'm trying to think of cases where people could discontinue in a carefree way, knowing that they're not going to be faced with this sort of argument. When could people discontinue?
Well, they could discontinue if they have conducted themselves consistently with the overriding objective.
Right. So the cost protection is there only to protect good claimants.
Well, it's there to protect those who don't impede the just disposal of the proceedings to a high degree.
Right. So we're including the words now to a high degree.
I'm quite prepared to accept that in the Atos case, that is the way that the provision was approached. If a litigant conducts themselves in a manner which impedes the just disposal of the proceedings to a high degree, then in my submission, they are a proper candidate for the loss of their quox shield.
Right. So
that's what the rule says.
Right. Well, it's not what it says. I mean, in a sense, not what the rule says. It's apparent that as soon as one has to parse the rule, it doesn't provide its own answer in any given case. So you're prepared to say obstruct to a high degree, based upon
impede to a high degree.
Sorry.
Impede. Rather than render impossible. Which is
impede to a high degree.
Can I just ask this? The overriding objective speaks of dealing with a case justly, and at proportionate cost, and then sets out all the various matters which arise. So it's dealing with the case justly by reference to proportionality, cost, and so forth. So just disposal of the proceedings, does that just mean the same? Is that just dealing with the proceedings?
Resolving the proceedings conclusively in a just manner.
Yeah.
Where just is defined by 1.1.
Well,
Why is disposal limited just to the final solution? Surely disposal has got to do with how you deal with the case.
Perhaps.
I thought that was your argument. I mean, if disposal is simply the final resolution, then large parts of the overriding objective are sort of neither here nor there.
Well, disposal is the process of resolving the proceedings.
It's really the same as dealing with, isn't it?
Yes, they are synonymous. In fact, although the wording is very different, words used are different, 44.15.1c is actually almost the mirror image of 1.1, 1.2. One is operating in a way that is antithetical to the overriding objective. One dramatically throws off one's quot's shield.
But really, the conclusion, the implications of your argument is that any claimant that isn't entirely truthful, vigorously energetic, so on and so forth, is at risk.
Even the claimant with a particularly bad memory. We don't even have to get to not truthful, but a poor memory, a poor historian.
Well, it would be a matter for discretion. Of course, somebody who has a poor memory, a poor historian, is unlikely to find themselves in this territory. People who, for example, litigants who fail to abide by their disclosure obligations, serve evidence from witnesses that is questionable as to whether those witnesses, for example, can properly give evidence in the case, who behave in a manner which is antithetical to the overriding objective. Should those litigants be protected by quotes? That's the point.
Well, the thing is that Parliament has clearly provided that they should. That the whole point of Cox, as I understand it, is to provide a systemic protection to a certain class of litigants who not replicated in other areas of the law. It isn't predicated by the statement that this is for meritorious claimants, or admirable claimants, or even average claimants. It's available to all claimants, and you would know much better than I do that many claimants are highly unmeritorious, don't run their cases well, drive people up the wall. But it doesn't. The law doesn't say that that's a reason for depriving them of quotes.
No, and I'm not suggesting
this is an exception, 44.15, so called.
If a litigant conducts themselves in a manner which is likely to obstruct the just disposal of the proceedings.
I mean, reading this as a relative stranger to this area, it seems that the exceptions under 15 and 16 are intended to engage with a pretty high degree of egregious conduct on the part of claimants, to take them out of just being losers. Many claimants are losers.
Yes.
That's not a reason for... They may be losers because the judge doesn't believe them.
Yes, but Judge Freedman got it wrong when he said that the provision was engaged only if a fair trial was impossible. That is wrong as a matter of law in my submission. The bar is not set that high. And whilst it is set in my submission at probably impede to a high degree, that is not the same as rendering a fair trial impossible.
Well, he clearly had some thoughts about the Arrow nominee's wording, because he tried again by putting it another way.
Yes.
We'll
And he was seduced by that concept, and that is the one that he adopted in his judgment. But in my submission, he was wrong to do so. The rule is not, the bar is not set so high. And ignoring the facts of this case for the time being, if a litigant conducts themselves in a way that impedes the just disposal of the proceedings to a high degree, such that they are eligible to have their claim struck out by a judge, but discontinues, for example, as in the Shaw case, when there was an application pending to have the claim struck out, should the court in those circumstances permit that claimant to retain their Quox protection? That's the nub of this appeal. Is it proper for somebody who has infringed the principles set out in 44.15.1c, such that they are eligible to be struck out, to retain their Quox protection simply because they're able to serve a notice of discontinuance immediately, rather than having to wait for a judge to strike out the claim? And that is the injustice that the appellant perceives in this area, which would be visited upon litigants if Judge Freedman was right. And I say that the discretion is wider than that afforded to himself by the learned judge. It may not be especially wide, but it is wider than the judge.
Should we look at Arrow and Atos then?
Arrow is in the bundle at page 69.
Thank you.
It's a case very much on its own facts, where there were false documents served, and not just once, but as I understand, 2 charges of false documents. And the court was asked to strike out that claim on the basis that a fair trial was no longer impossible by repeatedly serving false material. One had either corrupted the trial process to such an extent that one had forfeited the right to be heard, or else the conduct was such that a fair trial was no longer possible. And the court in that case accepted that submission and said that a fair trial was no longer possible, and the court should indeed strike the claim out. It doesn't, in my submission, stand for any greater authority than that. On the facts of that case, where a fair trial was impossible because of conduct on the part of Blackledge, the court was satisfied that it was appropriate to strike out. That doesn't mean, in my submission, that other conduct would not engage in those circumstances. 3.4.
Right. So where do you say the ratio of this decision is to be found? I'm looking at the head note at the moment, page 70, the bottom of paragraph 1. Litigant who demonstrated he was determined to pursue proceedings with the object of preventing a fair trial had forfeited the right to take part in a trial. His object was inimical to the process he purported to invoke.
Yes, but that is the submission that was deployed.
Sorry?
But that is the submission that was deployed by the party seeking strikeout. And that is what the court accepted, that the party who had conducted themselves with the object of preventing a fair trial had forfeited the right to take part in that trial. But what the case does not say, of course this is a case concerning somebody who wished to remain in the proceedings, not somebody who had resolved not to continue, which is our case. What the case doesn't say is that 3.4 will only be engaged in these circumstances, and that is the error that Judge Freedman, in my submission, fell into. discretion is wider than simply.
So this is
operating
not
offence.
discontinuance, as you say. This is persistence,
Yes. It's a
preventing persistence.
Yes, it is. And somebody who wished that this application was about dislodging that person from the judgment seat, not this is not somebody who'd resolved to discontinue their claim on the day of trial. It's a completely different case. And to extrapolate from this and say, well, that's the right test. No other conduct will be sufficient to engage 4415(1)(c), the meaning of those words, other than the arrow conduct, is in my submission wrong.
So where do we get the Chadwick formulation as
It's 54.
54? Thank you. Paragraph?
Paragraph 54, picking it up from F onwards, isn't it, Mr. Higgins?
My lady, I'm just racing to that part. Yes,
It's between F and G it really starts, but where a litigant's conduct.
yes, and it's the very last sentence really summarises what goes before rather pithily. But in my submission, arrow is an example of conduct that will engage 3.4 in that case, 4415(1)(c). For our purposes, it doesn't set the boundary or say this is the only conduct which can engage 3.4.
It could be said that what Lord Justice Chadwick there is doing is setting, if you like, the underlying principles. Where a litigant's conduct puts the fairness of the trial in jeopardy, where it is such that any judgment in favour of the litigant would have to be regarded as unsafe, or where it amounts to abuse of the process of the court as to render further proceedings unsatisfactory and to prevent the court from doing justice. And then it goes on, so it's identifying underlying concepts.
But the next words were the court is entitled. So what the judge is there doing is saying that these are examples
Yes.
of circumstances in which the provision is engaged, not in my submission, seeking to define the boundaries of the provision and say that no other conduct will engage the provision. That is the error in my submission that the judge fell into.
Well, then he carries on, doesn't he? The reason, as it seems to me, is that it's no part of the court's function to proceed to trial if to do so would give rise to a substantial risk of injustice. The function of the court is to do justice between the parties, not to allow its process to be used as a means of achieving justice. So again, he's underlying or identifying underlying principles, which then can be extrapolated.
That is, so where the judge Lord Justice Chadwick uses the words the reason, that is the reason to explain what he has said before. And what he has said before is that on the facts of that case, this particular litigant had deprived himself of the right to be heard by putting in so many false documents and polluting the stream of justice. He was...
Where does impossible come in? I'm sorry, I'm trying to... those who kindly put together the electronic bundle didn't make it searchable, so I'm not finding impossible just yet. I'm just trying to work out whether your real complaint about Arrow is that the judge misunderstood it, rather than that it's a case on its own facts, because there's plenty in paragraph 54, as my lady said, that might be regarded as being unexceptionable core principles. I'm wondering whether you're not really saying that the judge ought to have approached this in the arrow manner, but he instead summarised it, as we see, as saying that it's rendered just or fair trial impossible, if that's how he approached it. Whereas it seems that Lord Justice Chadwick, in the passage we've just been looking at, yes,
Paragraph 53.
53. Okay.
The sentence before, the last sentence in paragraph 53. Once the allegation is respect of which there was a substantial risk that neither of the two hours fraudulent conduct made a fair trial impossible.
Right. Well, that you say related to that case, the impossible.
Yes.
Whereas the statements of principle, the judge seems to go to quite a lot of trouble to find different adjectives which don't involve impossibility.
Yes.
But something involving something more like a, as you say, high degree of impediment.
Yes.
I understand that.
The fundamental error that I respectfully say the judge fell into was treating error as definitive of the conduct that could engage 3.4 when it is simply an example of that conduct. And Lord Justice Chadwick does not say in terms anywhere, but unless these parameters or these conditions are met, then 3.4 will not be engaged, and that is what the judge appears to have taken from Arrow, with greatest respect to him.
Well, he says he derived considerable assistance from the
Yes.
decision, and adopting the approach in Arrow, then he posed his question in one way and then in another way. So he wasn't saying, this is the ratio in Arrow and I must apply it. He was saying, we're a bit thin on the ground in relation to authority. Here's some useful guidance, and I'm going to adapt it. I mean, I paraphrase, but that's what he was saying, wasn't it?
So whichever it was, whether he was saying, I must do this, or I'm going to do this because I can and that's what I'm going to do, it's still the same error. It's still falling into error in setting a test where the bar is set far too high.
Right, well, that's helpful. Do you want to, is anything else in Arrow, or shall we look at Atos?
Nothing else in Arrow, my lord. Atos, the only reason I included Atos, it wasn't actually in my skeleton, but on another case I've been involved in recently, I did come across it, and I noticed that the defamation case, actually, that's not, the defamation case led me to this case. In Atos, there was discussion about the word obstruct in this context. Page 67. Paragraph 18. Mr. Bartz submits that in the light of the concession, it cannot be said that the second limb of 342B is satisfied. Mr. Bartz concedes that the word obstruct in that rule does not mean absolutely prevent. On the other hand, Mr. Bartz submits that the word obstruct does mean impede to a high extent. He bases that submission upon the fact that Rule 3.42b formulates two alternative grounds for striking out a statement of case. In my view, Mr. Bartz is correct in that submission. So the judge there endorsing the proposition that obstruct does not mean absolutely prevent, which is the test that, with respect, Judge Freedman applied, but instead means impede, and in that case to a high extent. Because I'm not going to be submitting that impede marginally or to do something that of a trivial nature can engage this provision. Of course it can't. It has to be impeding the just disposal of the proceedings and it has to be to a high degree. But provided that test is satisfied, one is then in territory where a claim is susceptible to being struck out. I come back to my point. And once one gets to that position where a litigant is not just a credible candidate, but is somebody who, if the judge heard the application, would have his claim struck out, and that person discontinues, what should the court do about it? On one view, the court should do nothing. One of the friend's interpretation of the rules is, well, this is a self-contained set of rules. It's a bargain between insurers and claimant lawyers, and the court should do nothing about it and just leave it where it is. But in my submission, that is too blunt an instrument. There are cases where it would not be appropriate to allow a claimant who is eligible to have his claim struck out and loses Quox protection to continue to enjoy that Quox protection on discontinuance. And in my submission, when analysing who the cohort are that can have their notice of discontinuance set aside, it is wrong to begin from the proposition that it includes only those whose conduct has rendered a fair trial impossible. Wider than that. I'll come on to momentarily to I'm substantially beyond my 1 hour.
No, you've been obstructed, but not prevented.
Only to a modest degree. So the facts of this case we can look at the end of my submission, but the general principle is in my submission. That's what's important.
Right. Well, I think we've got very clear in our minds the distinction between what the judge said and what you say you ought to have said on the test. So where do we go to next?
So then we go to the 38.4 test, and having found that the claim would not be struck out, even if it were resurrected, as it were, suppose one would then conclude, well, what's the point of setting aside a notice of discontinuance if the claim is not going to be struck out, if that is your purpose? The judge went on to analyse whether he should set aside under 38.4 and referred to the two cases of Shaw and Medtronic and Mab in English. So if we just look at those cases, Shaw is a decision of two decisions of Mr. Justice Lavender. The first decision is in the bundle at page 23. And one can see on in the heading that there were 5 defendants, various different flavours of Medtronic, Medtronic Corval LLC, Inc., Limited, and PLC. And the judge sets out in paragraph 2 some of the relationships between those defendants. He tells us that the claimant's father tragically died after a heart valve was inserted, and there was perhaps a set of proceedings that settled, and then 8 years later this set of proceedings was started up. And the judge decided on this application that the claim brought against the 4th defendant, I'm looking now at page 27 of the bundle, beginning at paragraph 16. The particular claim disclosed no reasonable grounds for bringing a claim against the 4th defendant, and he struck out the claim against the 4th defendant. As against the 1st and 3rd defendant, the proceedings had been served out of the jurisdiction. The judge concluded that should not have occurred, and he set aside Master McLeod's order insofar as it related to the first and third defendants and set aside the ability to serve the claim form on the first and third defendants out of the jurisdiction. So that was the decision. D1 and D3, permission to serve out of the jurisdiction set aside. Quox remains in play there. Particularly the claim struck out as against D4, Quox obviously disapplied as against D4. Interestingly, a theoretical question here, could the judge have gone on to strike out the particulars of claim or the claim against D1 and D3? They hadn't been served, but they had been issued, and presumably, if they were susceptible to strike out, that's something the judge could have considered, but for reasons that aren't explained, that is how the case concluded. So a second application was then launched, which is at page 33, the decision in the second application. And it's not in dispute, or wasn't in dispute, that the fifth defendant was in exactly the same position as the fourth. So the reasons that justified striking out the claim against the fourth defendant also applied to the fifth. And the fifth defendant had applied to strike out the particulars of claim against it before that application could be heard, before that application was heard. The fifth defendant, sorry, the claim was discontinued as against the fifth defendant. One was left in a situation where there was an enforceable cost order against D4, but no enforceable cost order against D5. And the D5 applied to set aside the notice of discontinuance so that its strikeout application could be heard. Judge refused to do that in the circumstances of that case. At paragraph 53 on page 47, he said, "I'm not persuaded it would be appropriate to do this. Prima facie, the claimant has a right to discontinue under 38.2. It was a proper use of that power and to be encouraged for the claimant to recognise, in light of the first judgment, that her claim against the fifth defendant was not sustainable, and to discontinue that claim. The court has power under 38.4 to set aside a notice of discontinuance. The paragraph does not identify the circumstances in which the power should be exercised. The only guidance on that point is para 38.4, one of the White Book, to be found in 2 cases which are cited with the proposition that a court may set aside a notice of discontinuance of an abuse of process, but there was no abuse of process in the present case." And the judge went on to say that the Rules Committee may well wish to look at these provisions, given the obvious difficulty that the judge perceived in dealing with them. Because we have 2 defendants, one of whom has an enforceable cost order, and the other does not, in almost identical factual circumstances, save that a notice of discontinuance was served after the application to obtain an enforceable cost order was issued. And that case then fed into the case of Mab and English, the decision of Mrs. Justice May. And in that case, again, I say that the court, quite a hard case, it's a claimant who had a medical negligence case, and the defendant in that case was seeking to set aside the notice of discontinuance. And in that case, Mrs. Justice May stated, paragraph 35 on page 21, 35, accordingly, whilst I can see the effect of Rule 38 and 44.15 taken together can give rise to a situation in which a defendant, as here, loses the opportunity to obtain the benefit of the exception, I cannot conclude that there is any inherent unfairness in a claimant taking advantage of the result that the rules together permit, at least in their current form. and would not rule out the possibility of a case falling short of fraud, in which the behaviour of a claimant or their solicitors might on the facts be so egregious or cynical as to justify setting aside a notice of discontinuance in accordance with the overriding objective. But this case is not so extreme as to lead me to that conclusion. And those are the words that, Judge Freedman alighted upon when deciding whether or not to set aside the notice of discontinuance. Again, you have my submission in written form. I say that that is to put matters too high, that the wording of 38.4 affords the court an apparently unfettered discretion. The court may set aside, of course that has to be exercised in accordance with the overriding objective, but to interpose or read into that provision if the conduct is so cynical or egregious is, in my submission, to take matters too far.
You refer, understandably, to the overriding objective a lot, but doesn't the court also have to have regard to the statute which underpins quox?
So the rules obviously are...
Well, the rules are one part of it, I accept that, but does in considering where it is and where it isn't appropriate to deprive claimants of the cost of protection, it's surely appropriate to have regard to the reason why it's there in the first place.
Well,
it's not just the overriding objective, is it?
So I'm not sure what status this document has, but there are two documents at the end of the bundle. One that my learned friend has provided, which is the Civil Justice Council response, June 2012. So I'm not convinced that either of these documents necessarily would pass the admissibility.
So these are sort of travaux preparatoires, are they,
Yeah.
for the legislation?
I think my learned friend will address you on what this is. I confess that I was a little confused as to what precisely it was, because it appears to refer to what the rules might be, and the fact the words used in the rules are not the words used in this note. I'm not sure how helpful it will be.
No, I was making a broader point, which is that quox is an unusual feature in the landscape, legal landscape, and it's there for a reason. And so it's not just the overriding objective, is it? One also has to have regard to the purpose of the regime in the first place.
Absolutely. And if one looks at Lord Justice Jackson's paper for the Civil Justice Council on 21st of March 2014, which is page 342 of the authority bundle, he identifies a number of separate reforms that he has introduced. So, not he's introduced, but have been introduced. And in particular, 7.44 sideline.
Yes.
Claimants in personal injury claims are protected by qualified one-way cost shifting. This is not an elegant term, best phrase I could devise. It means cost protection subject to exceptions which are intended to weed out those who do not deserve such protection. And in fact, that purposive way of thinking, if I can use that turn of phrase, was adopted by Judge Maloney in the Gosling and Screwfix case at page 184. That case concerned what is meant by fundamental dishonesty. And there were competing arguments about what fundamental dishonesty could or might mean. And at paragraph 44 on page 195, Judge Maloney identifies what he says is the correct approach. He says, it appears to me this phrase in the rules has to be interpreted purposively and contextually in the light of the context. This is, of course, the determination of whether the claimant is deserving, open quote, close quote, as Lord Justice Jackson put it, of the protection from cost liability that would otherwise fall on him, extended for reasons of social policy by the Quox rules. It appears to me that when one looks at this matter this way, and he goes on to talk about dishonesty, which is central to the claim, fundamental dishonesty, which is collateral and peripheral, but there the judge is alighting upon the concept of a deserving claimant, somebody who deserves to have cost protection, and interpreting the rules purposively so as to ensure that that category of litigants is protected. That provision was referred to in the Court of Appeal decision of Howlett and Davies, the relevant parties on page 208, the meaning of fundamental dishonesty. The two paragraphs 44 and 45 were read out. In paragraph 17 in Howlett it says, in the present case, neither counsel sought to challenge Judge Maloney QC's approach. Mr. Bartlett spoke of it being common sense. I agree. And so that criteria of the deserving claimant has, in my submission, obtained a degree of acceptance at county court level and now in the Court of Appeal for differentiating between those who are fundamentally dishonest and those who are not. And there is no logical reason why, if the concept of a deserving claimant is relevant to fundamental dishonesty, the two are not particularly obvious bedfellows, why deserving cannot or should not also apply to 4415. And this brings me back to my overarching point, which is that if a claimant conducts themselves in a way that their claim is liable to be struck out as obstructing the just disposal of the proceedings, and they are not a deserving claimant for Quox protection, should the court nevertheless allow that claimant to discontinue and retain that Quox protection even though they don't deserve it? In my submission, the answer must be no, and we can talk or discuss where the boundary sits. It doesn't sit where Judge Freedman put it, impossibility to have a fair trial, lower than that. And I said I'm going to come back to the facts of this case later on. That can has been kicked down the road some distance. But the reason that this appeal is, in my submission, quite an important appeal is not because of the facts of this particular case, or whether on the facts of this case A should have happened or B should have happened, but the more general principles that ought to be applied.
Yes, well, we grasp that. So how do you want to deal with the district judge's decision and
the district
and the
judge had case managed this case. She was on the ground and she was the trial judge. She had discerned that the case was inconsistent with the evidence, and in fact it was difficult to see how the case could properly be opened. It couldn't be opened consistent with the pleaded case because the evidence that was going to be led didn't support that, and it couldn't be opened consistent with the witness evidence because the pleaded case didn't support that. And so the judge was acutely aware that the case was in something of a difficulty in terms of it being progressed. She stood the case down for instructions to be taken as to what the claimant wished to do about that, and approximately an hour and a half, 2 hours after the case was due to start, the notice of discontinuance was served. And as I say in my skeleton argument, the factors that the judge was properly, in my submission, entitled to take into account when deciding what to do about this, I'll set out at the bottom of page 21 in my skeleton. A and B are the inconsistency. At C, I point out that 528 days had passed since the conflict had arisen and no attempt had been made to regularise the position. D, at 11 o'clock on the day of trial, claimant's counsel remained unsure as to what the claimant's case was. E, the judge had indicated provisionally she would be unsympathetic to any late application to amend the particulars, which would, in my submission, have been entirely appropriate. No such application had even been made. There was no draft amended particulars of claim. No evidence had been served in support of any such application. The particulars had stood for 902 days, in fact, since they had been issued. And the pleaded case was that the ladder was secure with string, when in fact the truth was apparently that there wasn't any string and it wasn't secure. And Claimant had been running a case that was collateral to the true facts. Claimant asked for the matter to be stood down. No real prospect of that trial being effective on the 16th of June. The rules prevented the trial being adjourned to another day, save in exceptional circumstances, the practice direction relating to fast-track trials says that the court will not allow failure to comply with a rule or court order or cause an adjournment unless the circumstances are exceptional, and that must mean exceptionally good, and they weren't. And there were difficulties in relation to the medical position. Claimant hadn't disclosed his medical record for 3 years. He'd utilised court time in the month before the trial seeking to increase the ceiling of his damages, and there were proper issues concerning whether the claim was a genuine claim in any event. All of those would have been explored in cross-examination, if appropriate. If the evidence led a certain way, then obviously the case would have gone a certain way. And all of that couldn't happen because the case couldn't start, because it was improperly constituted. The pleadings did not synchronise with the evidence. And the claimant was not in a position to open the case absent some sort of amendment which hadn't been telegraphed in advance. In those circumstances, as I set out in paragraph 27 of my skeleton, the judge said specifically that it was the claimant's case to progress, his obligation to assist the court in promotion of the overriding objective, including narrowing the issues and dealing with matters proportionately. He chose, as he's able to so to do, to drop his claim at the 11th hour and 59th minute, having made an application in May 21, the inevitable outcome of which would be to increase costs and take up additional court time and resources by virtue of additional listings and hearings, using time of both court staff and the judiciary in addition to the incurring of today's costs and use of court resources. I do not consider that his conduct in that context can be otherwise than to obstruct the just disposal of the proceedings. The matter has been drawn out, and I am satisfied, costs having been incurred needlessly. I'm entirely satisfied that had this case been pleaded in accordance with the facts known only to the claimant, importantly my submission, the facts were entirely in the control of the claimant, as clarified this morning by counsel on his behalf, the inevitable consequences would have included, from a significant earlier time, the prospects of either being struck out one application for summary judgment or indeed of the court's own motion. Accordingly, I do consider that this is the type of case adopting the approach of Lord Jackson as to differentiation between those deserving of leniency in exercise of judicial discretion as to costs and those not so deserving, where claimants, in the face of what is first conflicting accounts and thereafter at a very late stage clarified, should not be protected from the exemption to qualified one-way cost shifting. So she was bringing into account all of the relevant factors in CPR 1, saying that the claimant's conduct was antithetical to the overriding objective, and that in those circumstances that engaged 44.15.1c. Judge Freedman said that that was all wrong, and that this conduct did not engage 44.15.1c, which obviously is the reason that we are here for the appeal. But I say that the judge was entitled to come to the conclusion that she came to. She was on the ground, she case managed the case, she was having to, she'd read the bundle, she was ready for the case to be tried, and even after the case was opened, it wasn't clear what the claimant's case was, and ultimately he discontinued. The question in those circumstances was whether he was deserving of court's protection, being a man who had run a case in the way he had for so long, and the judge determined that actually he had consumed all of the court resources that were to be allocated to that case, and that he had consumed all of the legal costs that could ever be allocated to that case for the purposes of a one-day trial. and that in those circumstances it wouldn't be appropriate for him to walk away from the case with impunity, effectively, protected by quotes.
I'm just wondering what the ultimate significance of the presence or absence of the piece of string was. I mean, I can quite see that it's a bit of a facer if you're about to go into a trial and you can't make your mind up as to whether there was a piece of string or not. I understand the inconsistency point. But the claim against the employer in this case was a failure to ensure that the ladder was securely attached. So whether the ultimate resting point for the claimant was apparently that he wasn't sure there was a piece of string there. I mean, one might think that the absence of a piece of string made for a better case than the presence of a piece of string. So I'm not overlooking the inconsistency, but I'm just looking at the particulars of claim here. It was essentially an unsafe system of work because it was a ladder that wasn't properly secured. And clearly the ladder wasn't properly secured on the assumption that there was indeed a fall. So in some sense, what does it matter?
Well, there's a specific plea, isn't it? Page 159, paragraph 1.2. The ladder was tied to scaffolding.
I understand that. Exactly. But I mean, in one sense, it's a better case for the claimant if there wasn't a piece of string. So just stepping back and looking at what the piece of string really has to do with all of this, it's only that the claimant has been pleading against himself. Doesn't make the system any safer.
Well, it's obviously a choice for him and his learned pleader.
Yes, and you're entitled to know what case you're facing, and I'm not doubting that it was appropriate for these proceedings to come to a screeching halt. But it's essentially a detail of the claim.
Probably important detail, though.
An important detail of the claim. Yes.
I'm sorry.
An important detail.
Important detail.
Important enough for it to be specifically pleaded in the second paragraph of the particulars of claim as something that was relied upon.
Yes.
So the allegation was that there was a piece of string that presumably was visible and could be seen to be retaining the ladder on the occasion of the claimant ascending it.
And then later on he says he's not prepared to swear to that.
Which begs the question, why did you cause the particulars of the claim to be signed, making that specific allegation?
I'm putting this to you really because the judge thought, from his experience, which far outweighs mine and the district judge's equally, as clearly has experience in this area, that this was mundane. It was the sort of thing that happens in claims of this sort.
Well, that, in my submission, is to relegate or neutralise the effect of the statement of truth at the foot of the particulars of claim. I certainly would not wish this court to endorse a practice.
So, no, but I mean, this is a particulars of claim that runs to a good number of assertions, and one of them has apparently come unstuck.
One of the submissions that was deployed at the trial was that if the claimant was going to say, I don't know whether there was a piece of string, or it's never formed part of my case that there was a piece of string, I don't know how it's got into my particulars of claim that there was a piece of string, that would constitute a waiver of privilege, and he would then have to disclose what his instructions had been in relation to that. So, again, that was something that the judge in my submission was entitled to have regard to, that this was a fine mess because of the way that the claim had been pleaded out, presumably in the claimant's instructions that he no longer wished to give to his counsel. His case had changed, or else there had been.
So it just comes down to is the presence of that sentence in the particulars of claim and the resigning from it subsequently impeding the proceedings to a high degree.
Well, the context of resiling from it. I don't think anyone's suggesting that if the attempt to resile had been made promptly or earlier on in the litigation, that would have impeded the just resolution of the claim to a high degree. But doing so on the morning of trial, in my submission, even on the facts of this case, the provision was engaged. And the judge was entitled, as she did, to conclude that this was not conduct which was consistent with the overriding objective, not conduct that was enabling the just disposal of the proceedings. It was the opposite of that. And that in those circumstances she was entitled to do what she did. As I say, I don't. The facts of this particular case are not of the utmost importance concerning the general guidance that is sought from the court in this area.
Were the courts below given costs figures?
I think.
And what the consequence of the district judge's decision is that X £1,000 incurred in costs by yourselves over the life of the proceedings are payable and enforceable?
Yes.
Was a figure given?
By the way, I've got it. I'm reminded, page 143 of District Judge Searl's order.
Sorry, quite right.
Bottom page 143, about £25,000 in total across the two defendants.
Thank you. And had the claimant persisted to trial, and as the judge found, no doubt lost, where would he have been in relation to those £25,000?
Well, the first thing is that he almost certainly couldn't have persisted in trial on that particular day. So the question for the judge would have been, do I adjourn this case to another day? And the answer would probably have been no, looking at the practice direction. The court should not adjourn a fast-track trial unless the circumstances are exceptional, which would mean exceptionally good, not exceptionally bad. So he'd have been back where he was, especially with a case that didn't have sufficient time to commence, couldn't be finished in the day, in circumstances where the judge would have been invited to strike the claim out.
Sorry, would have been invited to strike him out?
Yes.
Why?
Because his conduct.
Oh, so we're going round in a circle. Yeah, all right, okay.
So we're back to a position where his claim can't conclude in the day. There's no sense in opening it or starting it in the day. The judge would have given a preliminary indication she's not minded to adjourn, given all of the fault for being the way the case is lies with the claimant. So what was there to be done? The only possibilities were that he discontinues and then enjoys his quox protection, or else if he doesn't discontinue, he's likely to be struck out.
Right, so on the facts of the case, you say the judge wasn't right to say he could just have persisted to a loss and maintained his protection, because for practical reasons he couldn't have done that. But that's the facts of this particular case.
To proceed to a loss would have first of all required an amendment to the particulars, to synchronise the particulars with what his case was going to be. And the judge had already indicated that she would not be receptive to a late application of that type. And absent that amendment, it's difficult to see how a case could properly be opened. If the pleadings are not synchronised with what the submission in opening will be, then that presumably would form a different type of abuse process, seeking to press a case that is not pleaded in circumstances where the court's indicated that the pleadings need to be regularised before you can open your case. So he would have ended up in my submission back where District Judge Searl put him, which is his claim not being proceeded with, but with costs being enforceable to their full extent against him.
Right, now you've already taken us to the judge's decision for the issue of principle. Do you want to close things off by pointing to his decision on the facts.
Well, given the way that the judge, given the test that the judge articulated, it isn't surprising that he then found that the test had not been met, because he said that he would not set aside a notice of discontinuance unless, sorry, he would not strike the claim out unless a fair trial was impossible. I don't think anyone was suggesting that a fair trial of some description would have been impossible that day, but a fair trial on another occasion. In my submission, that put the bar too high. And in relation to 38.4, the so cynical or egregious test. Well, firstly, I'd say that's the wrong test. But secondly, one has to look at why the claimant did discontinue. He wasn't offering to pay the defendant's costs, or indeed any of the costs. He was seeking to discontinue so as to avail himself of his quox protection. And in those circumstances, in my submission, this was conduct that impeded the just disposal of the proceedings to a high degree, and therefore the then judge was wrong to hold that the district judge should not have done what she, in her discretion, being on the ground on the day of trial, decided to do.
All right.
Any particular points I can provide any further submissions? I just turn my back, my lord.
Of course.
Check with my instructing solicitor who. Thank you very much.
Thank you, Mr. Higgins. Yes, Mr. Hogan.
I'm obliged. My lady, my lords, what I propose to do is mirror Mr. Higgins' submissions by breaking them into three parts, dealing with the discontinuance, the strikeout, and the residual discretionary power point. But before I start on the first of those areas of submission, can I set out some general points about the theme of this appeal and the context? In terms of the context, the appellant has expressly brought this appeal on the basis that it is a test case and urges this court to find that the rules provide that the court has a broad discretion, however founded, to disapply quox where it is contended that it is just to do so. My starting point, and in a sense my ending point, is that there is simply no such discretion in the rules. If one considers the matter at a very high level, quox was introduced as part of the package of reforms in 2013, flowing from the Legal Aid, Sentencing and Punishment of Offenders Act of the preceding year, and is a scheme of very wide application. It is wider than the former legal aid scheme, in that it applies to rich and poor alike, and it applies to every personal injury or clinical negligence claim. Secondly, the scheme has been aptly...
I'm sorry, I'm writing this down.
I'm so sorry.
It's my fault. I obviously write slowly.
I'm so sorry.
It's quite all right.
I will follow the judge's pen.
Well, try.
Time-honoured tradition.
Yes.
The second point was that the scheme has been aptly described as mechanical in its nature rather than discretionary. So the significance of that is it applies to all circumstances unless one of a very limited number of exceptions apply, all of which are to be found in Part 44. A practical consequence of quox, therefore, is that in the majority of cases where a defendant succeeds at trial, they have to stand their own costs. And putting that in a nutshell, quox is there for the losers, the good, the bad and the indifferent claimants, who can therefore litigate without fear of losing their house. And fourthly, at a high level, there is nothing unjust in that, because the quid...
Sorry, I don't know what the third point is.
Sorry, the third point was the practical consequence of quox.
Thank you. Fourth point.
And the fourth point is that at a high level, there's nothing unjust in that, because it's a quid pro quo. in return for quocks, the compensating bodies such as the insurance industry obtained the abolition of recoverable success fees and ATE insurance premiums. And in a case that went to trial in the years before 2013, often a 100% success fee was applied with a substantial premium on top, more than doubling the costs of losing a case of trial. And so it is not contentious that the compensating bodies will have saved many millions, possibly hundreds of millions of pounds in costs across the board since 2013, set against what the old system was. If one then descends to the prism of this particular case, in terms of the discontinuance, it is acknowledged that this took place at the latest possible stage, but when it did take place, the claimant had quox protection, and he had a legitimate interest in preserving that protection. And the other side of the coin to that is the defendant had no such legitimate interest in setting aside the notice of discontinuance, because they weren't seeking to continue the proceedings, they wanted them immediately struck out. In terms of the strikeout, the significance of that...
Just a moment, you're getting ahead of me now.
Forgive me.
Right, so no legitimate interest for the defendant in set aside, because they were only doing it for cost purposes.
Exactly.
So, well, does this go round and round in the sense that you were discontinuing for cost purposes, and they were trying to stop you discontinuing for cost purposes?
And that leads to two further points. The first is that the claimant had the benefit of quox at that point, and had done so since the inception of his claim. So he had that continuing legitimate interest. The defendant had to seek to set aside the notice of discontinuance just to open the gateway, the doorway, to the strikeout that followed immediately afterwards. And what the court will have seen is that when I put the skeleton argument before His Honour Judge Freedman, I took the discontinuance point first, as it's anterior in time. His Honour Judge Freedman focused on the strikeout as being the more significant point, because if that point was well founded, then the notice of discontinuance faded into a secondary position. And that, I suspect, is why the strikeout point was taken in the skeleton arguments as the first point, because what the appellant has to establish is that the case should have been struck out under Rule 3.42b, but there is a line of authority, of which Arrow is only the first of 4 cases, which establishes that that is truly an exceptional jurisdiction, and the factual matrix of this case doesn't get anywhere close to reaching the high bar, which is inherent in that.
I mean, your fundamental position is that it doesn't avail Mr. Higgins to succeed on the point of principle as to whether it's impossible or just very difficult.
Exactly so.
Because he undershoots both of them.
He does. It's rather like a sort of limbo dance, where he just, however he puts his case, on the facts of this case, he can't get under it, effectively. That then morphs into the residual discretionary power, which he's urged in his written argument. But of course, if one then follows through where that would take this court as a point of principle, it would turn every case where a claimant bringing a personal injury claim loses at trial into an inquest into whether the claimant was at fault for not appreciating that he or she was going to lose at trial, and should have taken action either to discontinue or otherwise deal with the case at some earlier stage, meaning, in practical terms of the county court, satellite litigation without end.
So not just cases where a claimant has sought to discontinue and got into this current wrangle, but case where the claimant litigates to the end and loses.
Exactly so. And one can then imagine the submission being made to the county court trial judge. It should have been obvious at point X that factors A, B and C weren't going to stack up. And due to the fact that the claimant didn't address that point, we've wasted all this time and money defending this case to trial. That will be the sort of argument and challenge that will be mounted if this court were to accept Mr. Higgins and his submissions. So those were the points that I wanted to make in overview, so that the court would have them at the back of their minds as to what the significance is of the points that are being run. If I move on to the discontinuance point, in the bundle of authorities, there is a decision of this court called Staffy and Kazakhstan, which is at page 276. And the significance of this authority in my submission is it's the leading authority, certainly in the Court of Appeal, other decisions of significance being at High Court level, on the application or use of the power to set aside a notice of discontinuance. And the facts of the case are far removed from county court litigation, in that it was a claim in the commercial court to enforce an arbitration award which had been obtained overseas. And that claim was met with a plea of fraud, that the arbitration award had been obtained fraudulently, and this court and the commercial court should not permit enforcement. The plea of fraud had no independent life of its own. It was simply set up as a defence to the application to enforce the arbitration award. But there are three particular sections in the judgment which are of significance. The first is paragraphs 27, which is at 286 in the bundle, running through to the bottom of paragraph 31 at the end of page 287.
You want us to read all of this?
Can I say that I'm very conscious I said I'd be about an hour, but I draw this to the court's attention because what you will see at paragraph 29, which is at the bottom of 286 going on to 287, is His Honour Judge Simon Barker, Queen's Counsel, in an earlier case, set out a summary of principle. And that was expressly endorsed by the Court of Appeal at the bottom of paragraph 31.
Right, so the important bit is A to D on page 287, is it?
It is.
Right, shall we read that? Yes.
Obliged. And then the second is at paragraph 53 at the top of page 292.
Yes.
And the significance of paragraph 53 is the point being made by Lord Justice David Richards that the jurisdiction of the English court in civil matters is invoked for the purpose and only for the purpose of obtaining relief.
Yes.
And of course, once the underlying claim has gone, the question is, well, what is the point of resurrecting proceedings that have been discontinued? discontinued. And then in paragraph 54, he answers that point. In this way, he says, if it is permissible at all for those proceedings to continue, there must be demonstrated a very strong case for a continuing interest. And he therefore gives an example within the body of paragraph 54 that there might be such an interest if it could be demonstrated that notwithstanding that the claim had gone, findings of an English court might create an issue estoppel in countries where enforcement proceedings were pending. So there is a point for the case being continued or litigated through to a trial. He concludes paragraph 54 by also noting that there may be other reasons. He gives an example of a discontinuance at the start or during the trial. Do so. It all would depend on the particular circumstances. And so that brings me to the essence of the point about the discontinuance, and I've already flagged it up in my opening, that the claimant did have a legitimate interest because he had a substantive right to cross protection. He had evaluated his case on the morning of the trial after the district judge's intervention and decided to discontinue. And by doing so, he brought the proceedings to an end whilst maintaining his substantive box protection. But when the defendant sought to set aside the notice of discontinuance, it was not in order to take the matter through to trial, because that wasn't the defendant's intent at all, and that, if there had been an underlying reason for it, might have been a legitimate interest. It simply wanted the proceedings instantaneously struck out. So the resurrection of the proceedings had no legitimate interest at all when viewed through that lens.
Obviously, drawing facts out of the air, but let's suppose you were a defendant in a very high-profile defamation case or something like this, which had arrived at the door of the court, and suddenly a notice of discontinuance was served. You might very well have a legitimate interest in saying, well, actually, no, now that we're here, I'd like an answer to this because of my reputational issues.
Yes, I mean, the judge would then have to grapple with the issue whether the discontinuance was in itself the answer, or whether there needed to be matters going further forward which needed findings made, maybe conduct or fraud or something of that nature. But in essence, there needs to be something more than wanting to play procedural games and then open up a COSA. Can I also say this? Although not binding upon this court, this isn't the first time that this issue has arisen before two High Court judges. And there are in the bundle of authorities two decisions of Shaw and Medtronic and English and Mab, of which English and Mab is perhaps the more helpful because it illustrates some of the difficulties inherent in what the defendant's trying to argue this court should do. If I deal with the first one, which is Shaw and Medtronic, Mr. Higgins took you, I think, to the key parts, which are page 47 of the bundle of authority.
Bundle page 47.
The red sidebar passes at the balance of 51 through to the conclusion of paragraph 54.
Yes.
But the essential point, which is significant in this case, is paragraph 53, whereas Mr. Justice Lavender finds that the claimant has a right to discontinue, which is not fettered by any considerations as to whether it's a personal injury claim or not. It's a proper use of the power, which is a significant point because the claimant is effectively electing to use a right given to them by the law, and to be encouraged because, of course, the claimant is discontinuing on the basis that they want to draw an end to the proceeding and not invoke further use of court time or further resources by the parties. So the point that I would urge upon the court from that judgment is that effectively there shouldn't be a discouragement from the higher courts for claimants to re-evaluate their cases, admittedly done on a very late stage, by, in effect, raising the spectre that if they choose to take a particular course, then they can be hit with a cost penalty for doing so.
Well, let's suppose in this case, because I think something similar happened in Shaw to at least one of the defendants. Let's suppose after only 200 days, the defendant or one of them had written to you and said your case is hopeless. Look at these pleadings. That might, I suppose, have lent some strength to an application if you'd persisted and then dropped it at trial.
It would have added to the argument, but of course, at the stage of close of pleadings, the defendant has already set out in their defence, you're going to lose this case, and for these particular reasons. And in effect, what one comes down to perhaps, is this overarching or underlying proposition, however one puts it. When a claimant loses at trial, they may lose for a variety of reasons. It may be because they're a hopeless historian. It may be because they've misjudged the strength of their case. It may be that the defendant's witnesses come across much more strongly than they did on rather scanty witness statements. All these particular points could arise. But underpinning all of them is the fact that, looked at with the benefit of 20/20 hindsight, the claimant objectively misjudged the strength of their case. There may be scope to say that it should have been more or less obvious, but then one comes down to the fact that Quox sweeps them all up, whether they're claimants who have been, less cognizant of points than other claimants may have been. On the...
It is a fact, isn't it? And I am speaking for myself now, but when one moved into the no examination in chief witness statement stands as examination in chief, it may be said that some witness statements were better drafted than others. And that could affect the conduct of a trial.
Undoubtedly that is the case. And there is also, of course, as we know from a lot of learning in the higher courts, exposition as to how human memory works.
Yes.
And how, for example, you may believe a certain state of affairs in 2018. When you come to do your witness statement in 2020, you may not be so sure of what you thought the position was in 2018. But of course, that is just again another feature of litigation. It's not exceptional in any shape or form. The case of English and Mab, then, if I move on to that, is Mrs. Justice May's decision. And again, it's paragraphs 33 to 35 at pages 20 and 21 of the bundle. And again, the facts of this case are, as Mr. Higgins has noted, a clinical negligence claim. It was a claim where there was an application to strike out. It was a claim where the claimant discontinued, enjoying the benefit of Quox protection. And in her discussion of the application to set aside the notice of discontinuance, Mrs. Justice May highlighted in her conclusion some of the difficulties of the application and what the court was being urged to do. The first point in paragraph 33 is the difficulty in identifying at what point in the proceedings a claimant might effectively be precluded from discontinuing. At what point effectively do you say the claimant should have discontinued and wouldn't face adverse cost consequences, potentially? And at what point do they become live? And the difficulty for that is that it would require an in-depth, intensive evaluation of the merits and motivations of the parties as part of some sort of inquest at the end of the case. The second point I take from the judgment at paragraph 34 is, of course, that there's no rule preventing a claimant with Croc's protection from taking steps to secure the benefit of that protection while it still exists. And this is where I part company with Mr. Higgins. Part 38 applies to every type of claim, whether it's a personal injury claim or not. There are no special rules for discontinuance of personal injury claimants. That morphs into the consideration that the cost consequences for a claimant who discontinues in a personal injury claim, absent Quox, are exactly the same. When those notices of discontinuance went in, deemed orders for costs were made in favour of the appellant against the claimant. But where Quox adds the extra layer is that those orders were not enforceable. The court may recall in the old days you had what used to be called the football rules order, made at the conclusion of a trial where there was a legally aided plaintiff. But of course that order doesn't need to be made anymore because the rules provide, in effect, that that is the order, absent the particular exceptions contained within it. And so the final point in paragraph 35 of Mrs. Justice May's judgment is that while she noted the effects of Rule 38 and 44.15 can mean a defendant loses an opportunity to obtain the benefit of the exception, but that's not inherently unfair because the claimant is simply using what the rules permit in their current form. And she notes, of course, there may be exceptions to it. There may be instances of egregious conduct or even matters of fraud or cynicism, which might mean a different result pertains. But that's not going to be most cases, and it wasn't the case before her in English and Man. Finally, on the...
Can I just ask this? You know, in paragraph 35, there's words so egregious or cynical.
Yeah.
Do they derive from any earlier authority?
Not as far as I'm aware
Right.
of. I suspect it was simply picked up in argument before Mrs. Justice May.
Sorry, we're at paragraph
35.
35 in the middle.
But coming back to a point that I think my Lord raised earlier in argument, these are extreme cases, and the exceptions in the Quox rules deal with extreme cases, such as fundamental dishonesty or a strikeout. And similarly, that approach, in a sense, can be carried through to the application to set aside the notice of discontinuance. You've got to have something which amounts to a reason for the court to intervene to set it aside. The final point I wanted to raise on the discontinuance point was that it was raised in the written arguments that sometimes a claimant has to come to court to get permission to discontinue because of payment of an interim payment. In my submission, there's nothing in that point because the requirement of permission is simply to act as a brake to ensure that the position of the interim payment is addressed when the case is discontinued. And one anticipates the normal order will simply be an order for repayment of the interim payment with interest possibly, but not morphing into a broad merits-based evaluation as to whether the claimant should have permission to discontinue. Provided that the interim payment is dealt with by an order, it's a separate question as to whether the claimant can actually afford to pay it at that point in time. So for all those reasons in my submission, not only is was His Honour Judge Freedman right about the not setting aside the notice of discontinuance in this case? But what the authorities clearly demonstrate from the Court of Appeal downwards in the Stati and Kazakhstan case is that you need to have something pretty exceptional to set aside a notice of discontinuance. And you need to have a legitimate interest in the proceedings continuing. And that is simply antithetical to the notion that you resurrect them briefly in order to simply strike them out in the next breath. My Lords, I'm conscious of the time. I'm about to move on to the strikeout point, and there may be some little time as there's 4 cases to get through.
Well, do you want to start on the first one?
I'm obliged. If I deal with some points about the facts before moving on to the law, then I can deal with that comfortably before the short adjournment. The court is very familiar with the facts of the case by this stage, and it was, in a sense, a run-of-the-mill accident at work which took place in May 2016. In effect, the claimant's case was he fell off a ladder, and a properly secured ladder would not have fallen underneath him in circumstances enabling him to fracture his heel and shoulder. As my Lord has indicated, the issue of the string is something of a red herring. There are no real conceivable circumstances in which a string would support the weight of a grown man coupled with a ladder when falling. But it's also right to note that there was a discrepancy with the witness statement, and I think my Lord also noted that there are 4 entries in the medical records which are all slightly discordant in terms of what had happened. But none of this is out of the ordinary, or indeed particularly exceptional, in any form of county court case, which takes place over a period of years, and is not dependent primarily on documents, but upon human recollection as to what happened. And indeed, if one puts oneself in the position of the claimant, all of this will of course have happened within a space of a few seconds of time. It was his first day on the job. He mounts a ladder, and then he comes sailing off the ladder, and then he has to reconstruct in his own mind what happened and why he fell. It's also right to note that absent this point, there were no problems in effect with this case. And by that I mean there were no defaults procedurally. The claimant wasn't in breach of a rule, a practice direction, or any court order. And if the case had gone the distance to trial, conceivably he might have won, because the judge, having heard all the witnesses, would have been able to put all the pieces together. But probably, as His Honour Judge Freedman noted, he may well have failed if he came across as a hopeless witness whose evidence lacked cogency. But if he had failed, one comes back to the point that Quox would still apply. To take my Lord's point raised earlier, if at some point anterior to trial the appellant had applied for a reverse summary judgment, Quox would still have applied, because that's not one of the exceptions in Part 44. And so when one considers how this matter unfolded before the district judge, again, as the court has noted, this was done on the hoof in a relatively short period of time on the day. I should also make the point that this was being done over a video link, so it's never as satisfactory as dealing with it in person. So there was that problem. And of course, I'm afraid to say the district judge didn't get much help when the submissions were put forward, because no authorities were put before her. And as my Lord has already noted, there is an absence of guidance in the White Book to Rule 44.15. And so she accepted that she had a broad discretionary power, and that really is why she went wrong. When the matter came before His Honour Judge Freedman, he had time, and he reserved his decision, having heard argument, to go through the authorities, to put the conduct in context, and as this court has already noted, he regarded this as part and parcel of run-of-the-mill county court personal injury litigation. But he unpicked the procedural consequences, and in essence, my case is that he was right for the reasons that he gave.
You want to say something about impossible?
Yes, in effect, the case that was put before His Honour was the Arrow case. And in essence, what the judge did when he directed himself accordingly to that was not in a didactic way, or to say that this is what he has to do and this is what he has to apply. He drew upon it for inspiration and authority. He found it helpful because it was giving statements of principle in Lord Justice Chadwick's
But
judgment.
what do you say the ratio of arrow is?
It's to be found in paragraph 54. And in essence, what the ratio and arrow is that if you have conduct which is egregious in the sense that you're trying to sabotage the just disposal of the case, that can be a basis for striking matters out. In Arrow, it was forging documents to support your case. It didn't work, this came to light, but the very fact that there had been that attempt justified a strikeout. One can look at other examples, such as driving...
Sorry, just checking my own note. You point to paragraph 54 rather than to the expression in paragraph 53.
Exactly so. Because if one, forgive me,
We're at 118.
yes, because in effect, 53 is the example of the particular fact. Paragraph 54 is the exposition of principle. And again, although the facts of Arrow were far removed from this case, it illustrates the sort of continuum of conduct which would plainly fall within it. And of course there will be conduct which plainly falls without it. And of course, what His Honour did do was he expressed it in two different ways in order to test the point and the hypothesis. And then of course moved to the facts of the case before him and said, well, this is run of the mill, it's nowhere close to 3.42b conduct.
Right.
I
That'd be a
therefore
good moment.
propose to move on to the law, but perhaps after lunch.
Good. 2 o'clock. Thank you.
All rise.